apologize for that slight delay. Hopefully, in the next 20 minutes or less, I'm going to give everybody on this session an overview, a little bit about adult protective services and the different services that we provide. So, elder abuse, unfortunately, is still underreported, and the experts say that for every case that comes to the attention of either adult protective services or law enforcement, there are about 24 cases that go unreported. So, I appreciate the invitation to have the opportunity to speak to all of you all today. To bring this down here, in 2020, the Texas APS in-home program received over 117,000 intake report. And out of those 117,000, over 52,000 were confirmed as valid. So that meant that when we went out to the homes, our APS specialists found that there was some type of mistreatment that was occurring. On the bottom, I draw y'all's attention to Bexar County here in San Antonio. And for some reason, Bexar County continues to come in as the second highest county in the state of Texas for the highest number of intake reports. First place is Houston, Harris County, and then Bexar County comes in second. When making a report to Adult Protective Services, I know it is not easy to pick up the phone and call and report something to our agency. But I'd like, if there's anything that, I want for you all to take away today from this session, is that Adult Protective Services is here to support our older adults and individuals with disability. And our ultimate goal is to make sure that we can try to have people age in place for as long as possible. And when we work our cases, one of the primary factors that we always keep in mind is we know individuals do not want to leave their homes. So we're always going to look at ways to keep them at home as safely as possible for as long as possible. There are two primary ways to report to our department. We have our abuse hotline at 1-800-252-5400, where if you decide to call in, an intake specialist will be on the other line asking a series of questions and will take all the information down. The other method to report to our department is through the texasabusehotline.org, and individuals can make a report online. The one thing that I would caution you all is that if you decide that you're going to make an online report, because I know there is a wait time for an intake specialist to come on, I just want to let you all know that if it's an urgent situation and you need APS to respond sooner rather than a little bit later, it's better to wait on the hotline and let the intake specialist take the information down, because our online reports, there might be a delay of a couple of hours before it reaches our local office. And as always, if this is an emergency, please call 911, because our first responders can always get out to the homes faster than we can. The eligibility criteria for the Adult Protective Services is that we serve anybody over the age of 65, is what we consider our older adult population. The APS in-home program also serves individuals who are 18 years and older with a mental, physical, or developmental disability that substantially impairs the person's ability to provide for their care or protection. In the next couple of slides, I'm just going to give you a slight overview of how we conduct our investigations and our process, so that you all will have a stronger understanding that what happens after somebody reports to our department. So With regards to elder abuse, there's many different organizations and that have a piece in conducting these investigations, and there's different scopes and jurisdictions. The APS in-home program is responsible for investigating abuse, neglect, and exploitation for those individuals who reside out in the community. And we investigate in private homes, we look at adult foster homes, and unlicensed boarding care homes with 3 or fewer individuals who are living in the homes. As far as our long-term care communities and our assisted living communities, that jurisdiction falls under our sister agency of the Health and Human Services Commission through the Long-Term Care Regulatory Division. The individuals that we investigate, we look at paid caretakers, unpaid caretakers, and family members. And so there has to be an ongoing relationship with the older adult or the individual with disability that we're investigating. The different allegations that we investigate in adult protective services, and often what we see is that when there's one form of abuse that's occurring and we start to look into these situations, we will often find other types of abuse that may be co-occurring at the same time. So we look at abuse, and abuse is broken down into physical, sexual, and verbal emotional. We investigate financial exploitation, and we look at neglect. And neglect falls under 2 categories. We look at situations when individuals may fall into states of self-neglect, and we will also look at caretaker neglect. And again, the different categories that we look at are physical, medical, and mental health neglect. A little bit about our investigative process. We talked about in order for us to get involved, everything has to go through our statewide intake and a report is generated. Once the report, the intake specialist takes the information down, they'll assign a priority to the case. And those priorities will determine our face-to-face contacts and how many days we have to get out to see the alleged victim. So priority 1 cases were out to see the person within 24 hours. Priority 2 cases, we have up to 3 days. Priority 3 cases, we have up to 7 days. And priority 4 cases, we have up to 14 days. I'd like to draw your attention to the next box that says case initiation 24 hours. I tried to make sure that I would not talk a lot specifically about Texas law, since we may have some visitors from different states. But here in Texas, the way the mandate reads is that within 24 hours, we have to begin all of our investigations. So that means that if Jennifer calls in a case at 2 o'clock, by 1:59 tomorrow, we should have started our investigation by contacting some collateral or possibly getting out to see the alleged victim within those first 24 hours. A part of our investigative process also involves interviewing our client, our alleged victim, and the alleged perpetrator. An alleged perpetrator in APS terms is the individual, the family member, or the caregiver who might be mistreating the individual. We will also interview all collaterals and gather any type of records that we need in order to help us either validate or invalidate the allegations. And so once we've conducted all of our interviews and gathered all of our evidence, we will make a final decision on the case, whether it's valid or invalid. And if the individual needs ongoing protective services, then we will move the case to services and provide those services to the individual. On the bottom, you'll see rolling service plan. And the reason that that's there is that I want to remind everybody that's listening in today that the moment that we determine that somebody needs some type of immediate assistance, we will immediately provide that to the individual. And I will get a little discuss our services a little further along the presentation. So, unfortunately, I know that sometimes people out in the community often get frustrated with adult protective services, and they think, why did I call them? Nothing happened, nothing changed. And there are certain rights, and an individual's capacity to consent plays a huge part on what adult protective services can and cannot do. It's one of the most beautiful parts of our program. And for me personally, when I was working out in the field, it was part of the hardest part of our program as well. So we can provide protective services one of two ways. We can provide services with the individual's consent, and we can also provide protective services without the individual's consent, only if it meets the definition in our statute under Chapter 48 of the Human Resources Code and the Texas Administrative Code. So when we're looking at capacity to consent, and capacity to consent is specific to the adult protective services, but the way that the law is written is that if because of a mental or physical impairment, the person is incapable of understanding the nature of the services that are being offered to them and agreeing to receive or reject those services, if they're not able to understand that, then that's an indicator to us in adult protective services that the individual's capacity is in question. And our next steps would be to be getting in touch with the individual's physician or first in order to help us make that determination. And if the individual doesn't have a physician, hasn't seen their physician, or the physician is not able to give us that statement, then we will take one of our doctors out to help make that decision. The other part with regards to our program is that all of our clients have rights. And so these rights are part of the reason why we may not be able to intervene in some situations, because our clients have the right to refuse our investigation, and they also have the right to refuse our services when an individual has the capacity to consent. And our clients also have the right to select the least restrictive alternatives. And our clients also have the right to refuse medical treatment based on their religious beliefs, and that's regardless of their capacity. And in our more serious cases, if we have to pursue some type of legal action, all of our clients are always going to be appointed an attorney ad litem. So next, I'm going to talk a little bit about indicators and what to be on the lookout. So I kind of like to approach this that our communities are like structures that support people's safety and well-being. And one of the most important ways we can all contribute to this ongoing construction is by looking out for the warning signs of maltreatment. So if something doesn't feel right, something doesn't seem right, please remember that APS is here to protect individuals, and everyone has the right to live free from abuse, neglect, and exploitation. So some of the physical signs of abuse, what to be on the lookout for, might be some bruising or, cuts or marks. And especially if ever you should see somebody that has bruising on the inside and outside of like their arms, that's an indicator that something could be going on. With regards to verbal emotional, if you're ever working with someone and they seem very fearful of a family member or a caretaker, or you're working with somebody, a family member comes home and all of a sudden the individual just stops talking, that's an indicator that something could be going on. But often what we see is individuals and these caretakers that don't always have people's best interests at heart tend to isolate individuals, and as they are isolating them, sometimes they're the threats of harm or they intimidate older adults. Um, Neglect, again, what to be on the lookout for is, the evidence of inadequate care. If the person doesn't seem to be well taken care of, if their clothing is dirty, soiled, you smell strong odors coming from the home, unsafe, unsanitary living conditions, lack of basic necessities or needed equipment. These are things to be on the lookout for. Any locks on the outside of the home where they might be locking somebody in the home is another indicator that something could be going on in that home. Other things to be aware of too might be, over medicating or under medicating. If somebody all of a sudden seems more disoriented or confused, in some situations we find where sometimes family members may not be aware that there's help out in the community. And so they might be over medicating individuals to prevent them from wandering. So, please remember that we're here to help, and there's a lot of communities within San Antonio that are here to support our older adults and individuals with disabilities. Behavioral indicators to be on the lookout for. I spoke about the fear, when or refusal or reluctance to speak when in the presence of a certain caretaker or family member. Sometimes with our individuals with intellectual or developmental disabilities, if their behaviors start to change and they become more agitated, that could be another indicator that something is going on in the home. And also, if you're hearing different versions of events for bruises that might be occurring, or excuses for why an individual may not be able to keep up with their monthly bills despite there being enough, those are all indicators, again, that something could be happening. With regards to financial exploitation, unfortunately, these criminals with keyboards, this just, every time we think we're getting ahead of the game, these criminals are out there, 2 steps ahead of us. But the good news is that Adult Protective Services and here in Bexar County, we've made a lot of efforts this past year as far as coming together and working more collaboratively in order to address these crimes. But things to be on the lookout for are unusual changes in the bank account or money management, unusual or sudden changes in a will or other financial documents, or possibly fraudulent signatures on financial documents and unpaid bills. Often what we see in Adult Protective Services is that when a family member or caregiver comes into the life of the older adult or individual with disability, there's a lot of unapproved withdrawals of funds using their ATM cards, credit cards, and just a lot of transactions taking place. So with regards to what to be on the lookout for with family members or caregivers that may not always have the best interests of the clients, when you see someone who's preventing a client from speaking or seeing visitors, friends, or family, that's an indicator that something might not be right. Often what we see is that these individuals just have a lack of affection towards the older adult or the individual with disability. Or sometimes there's a history of substance use disorders or criminal behavior or family violence that lead to these situations escalating and sometimes maltreatment to occur. So in the last couple of minutes, I just kind of wanted to focus on the different services that we offer in adult protective services in ways that we can help. Our services, Adult Protective Services, is not a long-term case management program. What we tend to do is that our service delivery is going to be focused on an individual plan in order to eliminate further risk of harm. And again, the APS specialist, along with our client, is going to define the problem and decide the best course of action. And so earlier when I spoke about the client rights and that we have to have the client's permission, it's before we can arrange any type of service, we have to have the individual's consent. So some of the different services that we offer might be setting up provider services, making referrals to Meals on Wheels, trying to link the individual up with the emergency response system. Again, we want individuals to age in place for as long as possible, but the key factor that we have to look at in adult protective services is the safety feature. We will refer to other agencies for continued assistance, and so that when we close our case out, the individual is linked up with a service that can continue to help them. We can assist with minor home improvements in order to have the individual live safely at home. Providing a safe environment. For example, if somebody was in a situation and they were afraid of a family member and they evicted them and they needed to get all the locks changed, we could help them with that. In other times, we can purchase medications, we can purchase groceries. We spend large amounts of money assisting individuals with utilities. I could spend more time discussing services, but I really want to finish my part of the presentation so I can pass it over to Linnell. But on the bottom of this slide, you'll see making a referral to guardianship. And I wanted to, in my last closing statements, I wanted to let you all know that in adult protective services, I referenced we go from least restrictive to most restrictive. And so least restrictive, again, is going to be what's out in the community. What can we do to have the person age in place? When we have to start looking at placing individuals, that gets a little further along the continuum because, again, a majority of the individuals that we serve want to stay at home. And guardianship is one of the most restrictive alternatives adult protective services can do. And it's really our last resort. And so we won't hesitate to make the referral to the guardianship program when it's necessary because we're always going to intervene for the individual's safety and take care of them. But the reason we consider it the most restrictive is because if the person is adjudicated incapacitated through a court of law, then that literally takes away all of our clients' rights based on what the final order is. And so that's why we consider it the most restrictive. And so I will pass it over to Linnell and let her take it away from here.
Thank you, Lisa. Welcome. Thank you, Linnell.
Okay, I'm live, I guess. Jennifer, can you see my slides?
We can. You're live and we see your slides.
Okay,
Thank
great.
you very much.
Thank you, Lisa. What a nice segue ending there with the guardianship thing. So as Jennifer said, my name's Linnell Lokemore, and I'm an elder law attorney, and I'm here to talk to you today about guardianship. So the scope of what I'm going to cover, I'll discuss with you what is guardianship in Texas, and I would like to be like Lisa and sort of broaden it to the whole country. Unfortunately, I'm only licensed to practice law in Texas. I don't know very much about guardianship in other states. So I think it's similar. I know it's similar, but I can't really speak to what guardianship's like elsewhere. So I'll talk about what is guardianship in Texas, who needs a guardianship, what does it take to create a guardianship, who pays for it, and then if you are a guardian, what do you have to do as a guardian? So diving right in, and my last slide is going to be some guardianship resources, and Jennifer has explained to me that you guys will get copies of my slides. I have some websites where you can go to see some of the documents I'm going to show you and get additional information about guardianship. So first of all, what is it? As Lisa said, it's a court process. One of the things I prepare when I'm doing an estate plan for people is a document called a declaration of guardian in the event of later incapacity. And just signing a document is not going to work. You have to go to court, and a judge has to listen to the evidence, and a judge has to find that it's in the best interest of the incapacitated person to, like Lisa said, strip them of all, or some, most, usually all of their legal rights, and appoint a guardian to care for the person and make decisions for him. When we're in the guardianship arena, the person for whom the guardianship is created is called a ward. And the person who is seeking to become the guardian is, during the court process, called an applicant to be the guardian. In a full guardianship, just some of the examples of decisions that the ward can no longer make for himself. He can't decide where he's going to live. He can't consent to medical treatment. He doesn't get to decide who he'll marry or divorce. He can't drive, and he can't vote. If the doctor who's doing the examination has determined that this proposed ward is not totally incapacitated, that the person does have capacity to do some things, then the court is supposed to create what's called a limited guardianship. And then the order, there's like a piece of paper that the judge signs creating the guardianship, and it's supposed to spell out what things the guardian continues to have the right to do. Usually what I see is the ward gets to vote and maybe have a little bit of money in a bank account that gets replenished every month. And sometimes the ward can have a say in where they live. So there are two types of guardianship. There's guardian of the person and guardian of the estate. The estate part is who takes care of the ward's money and pays the bills and runs the business if there is one. And you can have two different people. One, you can have one person be the guardian of the person who, takes them to the doctor's appointments, looks after the health, monitors relationships with family members, that type of thing. And then a different person can be the guardian of the estate. Who needs a guardianship? As Lisa suggested, it's the very last thing that we want to do. So there's an awful lot of incapacitated people in this world, but only a few of them actually need a guardianship. Whenever I see somebody, an applicant who thinks they need to be guardian of somebody else, something has happened. There's been some sort of triggering event. Maybe money has disappeared. Maybe the son who is the caregiving son, adult child, is suddenly driving a brand new car, and the other siblings get suspicious. Maybe there's been an automobile accident, and you can't get mom to voluntarily quit driving. So these are the kind of things that bring people into my office seeking guardianship. some worse examples, sometimes people who haven't signed their powers of attorney end up in a guardianship because they haven't appointed anyone else to reach the money. And now the elderly person has lost mental capacity and no longer can tell you where their money is even. And nobody else has agency under a power of attorney. And that's a tough one, you know, when you have to get guardianship just because somebody didn't sign a power of attorney. Lisa talked about exploiters. Sometimes we have to create guardianships to protect people from exploiters. And sometimes if you've got a disabled person who was born that way and their parents took care of them, but now they're aging into adulthood, if they're severely disabled, then we might need to have a guardianship. If they can read and write, then maybe we can do something less restrictive. Okay, what do you have to do to create a guardianship? Well, one thing you have to have is a doctor has to examine the proposed ward and fill out a physician certificate of medical examination. The lawyers call them CMEs. I guess a lot of people probably call them CMEs. At the end, the slides with the resources that Jennifer is going to give you a copy of, there's a link. The Bexar County probate courts have the most recent edition of the CME on the website. So if you're wondering whether the person that you're concerned about needs a guardianship, that might be one thing that you could start with, is grabbing a hold of that document, reading through it, and handing it to their doctor, to the proposed ward's doctor, and saying, what do you think? You know, look at this form, fill it out. Is our person here incapacitated? Even if you have the physician CME and the doctor has found that the person is incapacitated, the court's not going to create a guardianship unless you prove to the judge that there aren't supports and services available that would make the guardianship unnecessary. The person who is going to be the ward is entitled to an attorney. Lisa mentioned attorney ad litem. This is an attorney that the court appoints, and that attorney's job is to be the advocate for the proposed ward. So the proposed ward may have totally lost capacity, and it's clear that they need help and need a guardianship. But if the proposed ward tells their attorney ad litem, there's nothing wrong with me, I don't want this guardianship, then the attorney ad litem has to go fight the guardianship. And a lot of times all that means is the attorney ad litem just makes sure that the applicant for guardianship has jumped through all the proper hoops, that there's nothing wrong with the CME. The doctor might be required to come into court and testify. And, you know, the attorney ad litem's job is just to make sure the court sees the case from the proposed ward's viewpoint. Once the guardianship is created, every year the ward is going to get this piece of paper. It's called Rights of Ward, and I'm going to show you that on one of the next slides too. It's a wonderful document. It makes guardianship sound like, you know, the best thing to be in. Unfortunately, it's kind of an aspirational document, but it's good that we have it. It's good that everybody can read it and see this is what we're striving to create. You know, this is not supposed to be some sort of prison. It's supposed to protect and help the ward. If you want to be a guardian, you have to be trained. There's an online course through the Judicial Branch Certification Commission. You've got to go through a background check. If you're going to be guardian of the estate, then you've probably got to get fingerprinted, and the judge has to find that you are a suitable person to be the ward's guardian. So you may find it interesting. If you can be a convicted felon and still be a guardian, but if you've done any of the following things, then the law presumes that you're not going to be a suitable guardian. Convictions for sexual offenses, aggravated assault, injury to a child, injury to an elderly individual or disabled individual, in abandoning or endangering a child. If you've been convicted of a terroristic threat or continuous violence against the family of the ward or the incapacitated person. You know, pretty clearly, if you've done some of those things, then or even one of those things, you're not going to be suitable to be a guardian. And then all guardianships in Texas now since 2018 have to be registered with the Texas state agency. So if you're a guardian for a ward and the ward skips town and is picked up by law enforcement in some faraway place like El Paso, you know, they'll if they can figure out who the ward is, they can look them up, find the guardianship, and get in touch with the guardian to get that protected person back where they belong. Okay, this is the first page of the physician's certificate of medical examination. It's a 5-page document. It's really detailed. The doctor has to be present for the examination. They can't delegate it off to a staff member. The doctor has to have completed this report pretty close to the time that guardianship is applied for. And the crux of the form is this one question, this legal definition of incapacity, which I'm going to read to you right here. Is the proposed ward an adult who, because of a physical or mental condition, is substantially unable to A, provide food, clothing, or shelter for himself, B, care for the person's own physical health, or C, manage the person's own financial affairs? That if the doctor finds any of those three, A, B, or C, is present, then we've got at least a limited capacity. He's found to be partially incapacitated. And if you've satisfied the rest of the elements that I talked about earlier, then a guardianship would be appropriate. And that legal definition of incapacity is included in the form. And like I said, you can grab the form from the probate court's website. This next document, this is the document called Rights of Wards. We've had this since 2015, and this document has to be given to the ward every year and explained to the ward in language that the ward can understand. So, you know, I told you it was so aspirational. I just want to read this one to you. This is what guardianship is supposed to be like. Every ward is entitled to a guardianship that encourages the development or maintenance of maximum self-reliance and independence in the ward, with the eventual goal, if possible, of self-sufficiency. So it's supposed to be respectful and considerate and recognize the ward's dignity and individuality. And, you know, it sounds really good. It just in practice, I don't see these aspirations actually being fulfilled. Okay, who pays for the guardianship? Unfortunately, it's usually the ward who pays for everything. If you've got one of those disabled children who are aging into adulthood and they have to have a guardianship, then it's going to be the parents who end up paying. If a person who doesn't have any money really needs a guardianship, sometimes Bexar County can fund. They have a fund that can pay attorneys who represent the applicants. We have some charities in Bexar County, like Catholic charities, can help create guardianships. And then I want to share with you what I consider to be the absolute most horrible situation in terms of the ward having to pay the cost. So say you've got an elderly person who has some money, and you've got competing factions of the family. Say you've got one caregiving adult child who has access to the money, and then you've got other adult children who don't know what's going on. The caregiving child is not sharing information. The other children see the caregiving child driving around in a fancy new car. You know, tempers flare. Somebody files for guardianship, and then the opposing side of the family files a competing application for guardianship. So you've got two sets of attorneys, two applicants. Then the court is going to appoint that attorney ad litem to be the proposed ward's advocate. And in these kind of situations, sometimes the court will additionally appoint what's called a guardian ad litem. That person doesn't have to be a lawyer. That person's job is to investigate and report back to the court what is in the ward's best interests. So you've got now 4 lawyers, maybe, or 3 lawyers, plus a guardian ad litem who may or may not be a lawyer. And you've got court costs, and notices have to be published in the paper and other things, and, that many thousands of dollars. And the proposed ward may be absolutely clueless. They're just, living in their nursing home, and everything seems fine to them. And little do they know that their life savings is going down the toilet paying lawyers and court costs. So that is the most horrible situation I can think of in terms of guardianship, to be avoided at all costs, and happens all too often. Okay. Some things you can do to try to avoid guardianship, like I mentioned earlier, get those powers of attorney signed while you're still healthy. Sometimes an aging life care professional, also known as a geriatric care manager, can be really helpful when you've got competing factions of the family, or maybe you've got a cantankerous elderly person that wants his adult children to quit sticking their nose in where it doesn't belong. Sometimes just the presence of a neutral third party who is a professional, who knows what they're talking about, can soothe unruffled feathers, suggest some techniques to try to protect the incapacitated person while keeping family members informed, maybe setting up some bill paying kind of things with copies of reports going to family members, maybe just being the one to explain to the elderly person, exactly why it is they're no longer able to drive. Some things like that. Sometimes just the message coming from someone other than a family member can help the situation. Sometimes you can avoid a guardianship through the use of a trust. So trusts can be created while you're still healthy. You can create a revocable living trust and put all your assets into it while you're healthy. And that trust will name people who will be the trustee of the trust after you can't do it anymore. And that kind of trust can avoid at least a guardianship of the estate. So it can be very helpful. After the guardianship's already been created, there's still a role sometimes for a trust. And that's when somebody interested in the case can suggest to the court that the court create a management trust. And the assets are then transferred to the management trust, and that can sometimes allow the guardianship of the estate to be shut down. You just go on with the guardianship of the person. You've got like a corporate trustee in charge of the money, and that's more efficient and costs less. So, okay. Some small measures to avoid guardianship: putting one person on the bank account, letting bank statements copies go to the other children, sophisticated pill dispensers if your person has trouble taking their meds on time, a set in stone daily check-in time for a phone call, one of those life alert type necklaces, make sure your elderly person's okay. Some of these kind of things, these sort of delay the need for a guardianship. And, dementia is a progressive disease. The situation doesn't remain exactly the same for very long. So, anything you can do to just delay that need for the guardianship, you might never have to have it if you can delay it. What is a guardian required to do? So once you've become a guardian, now you're in charge. It's your responsibility. You've got to manage the food, clothing, medical treatment, and housing for your ward. You have to keep the court and certain relatives informed of where the ward lives and how their health is doing. There's a lot of mother may I. You have to ask court permission for an awful lot of things in a guardianship. It's very heavily court supervised. As a guardian, you have to provide detailed annual reporting to the court. There's a big, long annual report on the condition and well-being of the ward. There's also an annual accounting that has to be given to the court every year. And that accounting, it takes everything that was in the guardianship last year, reports every penny that came in, every penny that went out, and the ending balance has to tie to the penny to the bank statement. Again, I'm going to refer you to the Bexar County Probate Court website. They've got a nice document called Instructions to Guardian of the Person and Estate if you are interested in looking in more detail about what guardians have to do. I think I'm pretty good on time here, so I think I will just indulge into media for a moment. I recently watched a movie on Netflix. It was called I Care a Lot. And maybe some of you have seen it. It is about a professional guardian. And we do have professional guardians in Texas. They go through training, and then they can be the guardian for, total strangers. And in this movie, that's what this woman was. She was a professional guardian, and she was a thief. And she had fellow thieves that ran nursing homes and worked in the police department. So there was like this network of thieves out to take advantage of elderly people with money and who had no family to try to protect them. And so I watched this movie with horror, and I knew my clients were probably watching it too, and some of them have asked me about it. So can this movie, I Care a Lot, really happen? Well, some of the things can happen. If that physician's certificate of medical examination says, there's some questions in those 5 pages that deal with whether or not the proposed ward should be at the hearing. The doctor may say that the proposed ward isn't capable of understanding the legal proceedings or cooperating or participating in the legal proceedings, and that it wouldn't be in the best interest of the proposed ward to even attend. And if the doctor finds that, then that whole court hearing where the judge hears all the evidence and hears the applicant to be guardian talking about how, my parent can't take care of himself, the elderly person doesn't even get to see any of that. In the movie, the evil guardian, she would tell the nursing home, don't let the sun in, don't let anybody come see the ward. And a blanket prohibition on anybody visiting the ward is not something that the guardian can do. But if, say, the care facility, the nursing home reports to the guardian that, this sister is showing up and she's whispering in the ward's ear and telling her, you got to break out of this place and you shouldn't be here and you should go on a trip to Hawaii with me instead, then the guardian might need to go to court and limit family members' access to the ward. So that can sort of happen. And then, of course, the guardian controls all the money. So the ward is very likely not going to see, what's happening to their money. And then, like Lisa said, everybody wants to stay at home, but a lot of times wards, they're not able to do that anymore. So one of the horrible things in a guardianship is often the professional guardian has to place the ward in a nursing home. So those are things that are sort of true about that movie. But on the other hand, a lot of things about that movie were really not true. So first of all, it's never going to be a surprise to you if you are capable of reading and understanding what you're reading, and somebody's trying to get guardianship over you, you're not going to be surprised by it. It's not going to happen like in the movie where the evil guardian and the police just show up and tell you to, put your clothes in a suitcase, you're going to the nursing home. And one of the reasons is because of all the notice requirements. In Texas, if a proposed ward has to be personally served, so a process server hands them the paperwork and they get to read the application for guardianship and see what the allegations are that say that they don't have capacity. There is something in Texas called temporary guardianship, and you don't have to have the doctor's report. You do still have to be personally served with the application, but maybe no doctor has examined you because, there's no time to get the doctor out there because there's some type of emergency. But those types of guardianships only last 60 days. And after 60 days, the guardianship either goes away or you have a hearing on a permanent guardianship. And then, of course, in Texas, you're not going to become a ward in a guardianship without any representation. The court is going to appoint an attorney ad litem to represent you. And then we also have a program in Texas where we have court visitors. So once a year, somebody from the court staff, I think here in Bexar County, they've delegated that to Catholic Charities. Somebody will come visit the ward every year and talk to them and see how they're doing. And then, of course, you've got that nice document, the rights of wards, and that is a document to be given to the wards every year, and it has names of agencies to help. ACOG's on there, APS is on there. It's got email addresses and phone numbers, and the ward is invited to report directly to the judge if they think their guardian is mistreating them. So that movie, I Care a Lot, really is very likely could never happen like that in Texas. So be rest assured of that. So some final thoughts on guardianship: avoid it if you can. If you have a person who's a problem for you, you're trying to help your elderly parent, but they're cantankerous, they like to run down the street naked and you can't make them stop that. The judge's signature on a court order and your pretty blue letters of guardianship are not going to make your ward more cooperative. The guardianships are intrusive, they're expensive, they take away a person's rights. And, just finally, our Constitution says we all have the constitutional right to life, liberty, and the pursuit of happiness. But if you're a ward in a guardianship, do you really? So last of all, these are the resources that I would refer you to if you want to do some more looking into whether or not a guardianship is something to be pursued in a particular situation. I think you'll find these helpful. And if you think you need an attorney to help you with a guardianship matter, then I hope you will give me a call.